With that said, I want to go ahead and introduce Lisa. I know some people attending may already know you, Lisa, but it's always great to hear what's new and exciting and going on in the world of autism life and living. And if you don't mind, could you share a little bit about yourself and your background and the organization?
Absolutely, don't mind at all. Thank you everyone for being here. Some of you may know me, some of you may not. I am a single mom. I have two young men with autism. As they approached adult age, I started researching what would become of them when I was no longer here. And I couldn't believe the lack of viable options in terms of housing and support services. I said, okay, I got to do something. So I started Autism Life and Living. Our goal is to provide independent living community for this population. While we're in the process of developing this community, we have implemented our programs. So our programs are aimed at supporting their independence, their inclusion, and their socialization. So when they do eventually have to live on their own to the best of their abilities, they would be prepared to do so. So that's Autism Life and Living in a nutshell. The housing project, it is a big project, of course, as you could imagine, but we have an amazing leadership team. We have plans. The need is very great, and we want to come at it as an affordable, safe, and supportive option for kiddos that have autism and related needs.
Awesome. And I understand or am aware that you have a big event coming up this spring. Do you mind sharing a little bit about the upcoming spring event that
We
you have?
do. We rely heavily on our wonderful sponsors, such as Emily Taylor Law and our individual donors, and the fundraising events that we host and plan. So we have a big garden gala, April 7th at Scottsdale Plaza. So come on out and support the cause and have a great time. It's an outdoor brunch, and everything I speak of can be found at autismlifeandliving.org. So love to see you there and have a great time.
Awesome. Well, I'm glad I got the website right on the
Yep, you
fly,
did.
but
You did.
we'll follow up this for those of you attending with some additional links to learn more. So I have to say thank you, Lisa, for asking, telling, co coming up with this idea of doing this presentation and this webinar. It's really helpful information. It's kind of a big ask. Our topic is pretty broad today in terms of planning, but I'm going to do my best to cover some high level kind of elements of options that families should consider when planning for their estate, and especially taking into consideration any beneficiaries or heirs that might have a disability. Um, Briefly, again, same thing. I think many of you may know me or have worked with the firm, but just a quick introduction for myself. I grew up in the Midwest, have been in Arizona for 24 years. I went to ASU and then U of A, so I stayed once I got out of the cold. I'm a member of the Special Needs Alliance as well as the National Academy of Elder Law Attorneys. I feel very, very lucky to have practiced in this area of law for the last 15 years. And so have a wonderful team and thrilled to be talking about these things today. So excuse me. With that, I'm going to talk broadly about this idea of a special needs trust. So for better or worse, the terminology and the idea of a special needs trust is kind of a big term. What it really means in context is it's a tool. It's a tool that families, parents, individuals, as well as the government consider a way to allow for individuals who are means tested benefits, which we'll go into more depth about, retain not only the income, insurance, and resources they get from those benefits, but also have additional funding to allow for them to provide for additional items. And so this tool, commonly known as a special needs trust, can be known by a number of different titles. We hear S&T or CSNT as an acronym a lot of times. In Arizona, one of our Medicaid agencies calls them special treatment trusts. Sometimes you hear the terms first and third party trusts, disability trust, D4A, that's the federal law in which established the ability to have first party trusts, and D4C is pooled trust, supplemental needs trust, and more, because frankly, as long as the tool does the job it's intended to do and meets all the criteria, we really can call some of them anything we want. So our idea today is to really break down this whole idea of how do we have or establish a system for families, for individuals, to make sure that all of the options that are available to us from government services and benefits be maintained and protected throughout one's life. And so in doing so, I kind of want to break down three big areas that I think will be helpful for everybody. So the first thing we're going to talk about is estate planning. So estate planning is a term many of you know, but we'll break down what does that mean? What does a general estate plan look like? You may have your own estate plan at this point, so this is a good kind of refresher on the different elements that you can make sure you have and are active and accurate. We're going to talk about those government benefits, so the Social Security, the Medicaid, all sorts of different things that may or may not be in place. And then we're going to go back to the overarching concept of special needs trust and those tools that allow us to do good planning and make sure that to the best we can, we have all those elements maintained. So with that, I'm going to talk briefly about estate planning. Anytime I use the term estate planning, wills, trusts, we all kind of conjure up when we first learned about these and maybe watching Saturday morning cartoons and DuckTales, or if we, Sherlock Holmes, the reading of the will, some of these pop culture literature references to estate planning kind of conjures up these wealthy people who have this very fancy document that says where their fortune is going when they pass away. And yes, that can be an element of an estate plan, but really it encompasses a lot more than just a will or a trust. In Arizona, some of the common elements are going to be our healthcare directives, which we'll break down into different pieces. We're going to talk about last will and testaments. We're going to talk about trusts, talk about financial powers of attorney, but we also have to consider beneficiaries and co-owners and all of those pieces. So let's break that down a little bit. In general, anytime I'm talking about an estate plan, I'm talking about a legal tool or several legal tools that are going to allow for us to put in place the right team when we can no longer make or communicate our own decisions. And they're also going to allow for us to express what our wishes would be in some of those circumstances. And finally, yes, we are going to say what happens to our stuff. So with healthcare directives, for individuals who have the capacity to be able to make their own decisions and to effectuate a power of attorney, our healthcare directives are something we can put in place after the age of 18 to establish who will make and communicate our healthcare decisions in the event we're not able to do so. Generally, most common is a healthcare power of attorney. That is specifically who makes our healthcare decisions. In Arizona, it's common to see some other decisions made in that document, such as, do you want to be cremated? Do you want to be buried? Do you want to be an organ donor? Questions regarding autopsy. But this, frankly, for many of us is going to be the document that we use the most often while we're here. If you've had an outpatient or an inpatient procedure, upon admission, they're going to ask you if you have one of these. Very, very important and thankfully pretty easy to put in place because in the state of Arizona, the Attorney General does offer them for free through their website, and they just need to be witnessed or notarized. Similar with the healthcare power of attorney, Arizona uniquely has also a mental health care power of attorney. And I think this is something that everybody over 18, again, who can sign a healthcare power of attorney should have in place because it's specific to inpatient psychiatric treatment. For many of us who are hopeful that we'll never need inpatient psychiatric treatment, that's great. Then it's just an extra piece of paper. The reality is that for better or worse, it can come up for any of us at any time in the event of an injury, an illness, or ultimately at the end of life, or as we develop other types of diseases such as Alzheimer's and dementia. Sometimes that can require inpatient psychiatric hospital. With both the healthcare and the mental health care power of attorney, our goal is that if we've been able to put the right team in place at the appropriate time while we still can, then in the event we lose our ability to make decisions, that's going to allow us to avoid the need for a guardianship, to avoid the need for the court having to be involved, to take away our rights to make decisions and give them to somebody else, and hopefully just provide some clarity for our family about what our wishes are. I say family, but it could be family, friends, or professionals. In addition, usually part of an advance directive or healthcare package is going to be a living will. And this living will, despite the use of the term will, does not mean where your stuff goes when you die. It instead indicates what are your wishes in the event you're not able to communicate, and Commonly, you're being kept alive by life-prolonging procedures, so ICU level of care, or at the end, in terms of what kind of ongoing treatment should you have a limited capacity, such as an advanced Alzheimer's or dementia. And so many of us think of the big legal cases like Terri Schiavo, young women who were in tragic accidents being kept alive under using certain medical technology, and then families disagreeing about whether that's what they would want. This is our opportunity as best we can to share with those who are going to be making decisions what your perspective is and what you might want to put in place. So living will is very, very important and something to consider. Of course, we also have HIPAA. We need to make sure that the people who we want to make our decisions have the authority they actually need to talk to doctors, to get medical records, talk to health insurance companies. And then occasionally at the end of life or with a serious illness prognosis, some people have documents such as a do not resuscitate or a physician's order for life-sustaining treatment, commonly known as a DNR and a PULSE form. These are going to be really strict orders signed by your doctor that are indicating that you do or do not want very specific treatment. So not as common as the others, but really important to have in place. So healthcare power of attorney for those who have the capacity to sign the documents. This whole series of documents are going to be really important in establishing an estate plan. I think they kind of get put into the shadow because they're not fancy. They don't make the news as often as some of the other pieces, but very, very important for those of us who can sign them. If you have a loved one who has a disability that's impacted their ability to understand legal documents and sign documents, then you may have had to go through the guardianship process, and that is, again, similar. And so if you have an individual who is under guardianship, you're not going to have these documents, but as the guardian, you may still want to review and consider what you believe the decisions that you would want made on their behalf in the event some of these things come up. So important to know, important to think about. Similarly, on the financial spectrum, while we're still alive, we need to consider what happens if we can't make our own financial decisions. And so that's commonly a financial power of attorney, sometimes referred to as a general power of attorney, sometimes referred to as a property power of attorney. Again, lawyers get creative with the terminology they use, but the goal is to say if you can't make certain financial decisions, again, who is that team going to be? And it may be individuals, it may be family, friends, it may be a professional, but we want to make sure that in the event you don't have this power in place, we have a conservatorship. We want to make sure to the extent we can that we can avoid that. And so having this pretty straightforward document in place makes a lot of sense if you have people to make those decisions. We also have to be mindful that even if we have these legal documents as part of our estate plan, that under the law and as it relates to how our accounts and assets are structured, co-owners and signatories on accounts are going to have certain rights as well. And so sometimes those things can conflict one another. And we just want to make sure that when the time comes, we've got in place a consistent plan so the right people have signing authority, ability to access, that type of thing. So with both the guardianship, the health directives, as well as the financial, the conservatorship directives, we're also, we're just primarily focused on while we're here on earth taking breath and are for some reason unable to act. Sometimes with the financial power of attorney, that also means we may not necessarily be incapacitated, but it may just be helpful to have in place. As we transition into what happens to our stuff when we die, the shortest way to say it, we have to consider last will and testaments. So different than a living will, a last will and testament is a legal document that allows us to do a couple of things. First and foremost, it's going to allow us to nominate or give priority to someone to serve as a personal representative. The term personal representative is what we use in our Arizona laws, but commonly we think of the term executor as who's going to collect our assets, pay our bills, make sure everything gets to the right spot. So that nomination takes place in a last will and testament. A last will and testament also allows us to nominate a successor guardian or a guardian for minor or incapacitated adult children. And that's really important. So if you yourself have a child that you are a guardian of who's an adult, you want to make sure that your will expressly provides priority to who would step into your shoes in the event you passed away and didn't already have a co-guardian in place. So that's going to go in your last will and testament. Last wills also will say who gets what. So you might say your favorite dishes and silverware go to X, Y, and Z, and your cash gets split up, amongst 7 different people. It can be as detailed or as general as possible, but it's going to make sure that it spells out where everything goes. And sometimes, in fact, last will and testaments can include special needs trusts. These are what we call testamentary trusts. So the term of that tool that's going to allow for the asset to protect, to make sure we don't disrupt benefits, may exist, the terms of it, in your last will and testament. Now, there's a big caveat when we're talking about wills, and I think it's a commonly misunderstood fact as it relates to wills, is that in order for the person or professional we've nominated in our last will and testament to have the authority they need to go take those steps that we've directed them to take, a will must go through probate. So this idea of probate is the legal process for formalizing, authenticating a last will and testament if there is one, and giving authority to a personal representative who may be named in a will, or if there was not a will, then finding out who has priority to do that. So I think it's kind of a myth to think that if you put a will in place, you're not going to have probate. In fact, a will still govern the direction of your assets that don't have beneficiary designations or co-ownership. But in order for the personal representative or executor to have the authority we need, they're going to have to go to probate, open a court case. The court has to appoint and give authority to the personal representative, and then they're going to supervise the administration of the estate. Probate gets a pretty terrible rap, and it is what it is, but typically it does allow for things to take a little bit longer, to cost a little bit more, and it does, in some instances, require that notice be given and public information be shared with people who we may not want to have that information. And so commonly in Arizona, with our goal of avoiding probate, we're going to look at a couple different options, but one of those is a trust. So in Arizona, revocable living trusts, again, we get to use whatever terminology we want, but this idea that we're going to write a document, again, the document's going to spell out who's going to be in charge. We're just going to call them a trustee instead of a personal representative, who might be a trust protector or other advisors. It's going to direct the administration of your estate and what happens. Ultimately, a trust, though, is going to differ from a will in a couple different ways. One is that a trust is going to be a directive that's going to allow us to put into place what happens not only when we pass away, but beforehand, what happens now, what happens when we're incapacitated, if we're married, what happens when the first spouse dies, and ultimately what happens when the second spouse dies. And it allows for us to put into place all of these intentions and wishes and create an entity where we, in essence, are writing our own rule book, our own operations manual. The solution here for avoiding probate is that a properly funded trust will avoid probate, and that's the secret. Trust documents are not magic. You can print a trust off the internet. You can pay a lawyer a lot of money for a trust. However, the trust is only going to govern assets that are properly funded, meaning that the title, ownership, or beneficiary designation of the assets that you have is consistently funded, or titled with the name of the trust. And that in and of itself is a big part of estate planning if we're trying to use a trust for the purposes of probate avoidance, is to make sure that we've got our assets in line with our wishes by making sure that the ownership beneficiary designation is consistent with either our trust or our non-probate wishes. So trusts, again, I said it already, but they're not magic. The paper themselves isn't as valuable as you might think. It's actually the process of not only establishing the trust, but also keeping it funded. And so making sure when you buy a new house or you open a new bank account, it's got the right account owner, it's got the right beneficiary designation, so it all works consistently. These types of trusts, which might be family trust, revocable trust, may also include a special needs trust. So within the terms of the family trust, it may spell out, for example, that my assets will go equally to my 3 children. One of my children, Julie, may be receiving Social Security benefits or all tax benefits, or perhaps is vulnerable to outside influence, and so I may want to provide extra protection. So I can say that effective once my assets split and are available to go to my 3 children, that any share that might go to Julie be held in a very specific manner. This type of trust, that language can be held within the contents of a family trust. Now, you may also have a million different types of trusts. I'm trying to go as fast as I can, so we can't cover all of them, but we can have standalone special needs trusts, which we will go into more detail. We can have irrevocable trusts. We can have life insurance trusts. We can have Medicaid asset protection trusts. The list goes on and on and on. And so this is the most general way I can describe a trust, but important to understand kind of what type of trust you have and the purpose of it, and making sure we understand all of that. So with that, gonna kind of move on. Again, if we remember, we're talking about estate planning first. Got through that in about 18 minutes. That's going to include our healthcare directives, our financial directives, and powers of attorney, as well as wills, trusts, and all of those elements. Generally, our goal with those documents is to make sure we have the right people in place and we've got the right instructions in place, and that ultimately our assets go where we want them to go consistently through the use of our estate planning documents, but also our ownership and beneficiary designations. When we kind of transition over to benefits, now we're thinking about, okay, who are these people we want to share in our estate? If we've got the 3 kids, if we've got 20 grandkids, if we've got a number of different individuals, perhaps a sibling that you want to provide for. One of the things we want to consider is how might that inheritance impact the current circumstance they have. And for many individuals with a disability, that may mean they're receiving government benefits that consider how much they have in terms of financial resources or income. And so we want to make sure that if we're properly planning through our estate to provide for them, that we really have a good grasp on what are the benefits they're receiving now, what might they be receiving in the future, what might upset or disrupt the receipt of those benefits, and how can we prevent that. So that's why I want to take a few minutes to talk generally about the most common types of benefits that we see when we're planning for an individual with a disability in Arizona. So broadly, I'm going to talk about Social Security, I'm going to talk about Medicaid, and I'm going to talk about a few of the other acronyms and other things. So again, with this, if we're talking about Social Security, most of us who are watching the webinar may be familiar with getting our very first paycheck and thinking, you know, we got paid $10 an hour and we worked 10 hours. That means we're getting $100, and then being very not pleasantly surprised when we see our first paycheck, because a portion of it went off to the IRS, a portion went off to Social Security, et cetera, et cetera. So as you know, over the years, when you are paid or compensated, there are certain things that you're essentially forced to buy through Social Security, one of which is Social Security retirement benefits. The same is for Social Security disability insurance benefits. And so, you know, in the last 25 years that I've been working, I've been contributing to Social Security, and based on how long and how much I've contributed, when I'm ready to retire, or when that's not the accurate statement, when the Social Security Administration tells me I can reach full retirement age, they're going to tell me how much I can get based on how much I've paid in and for how long. And the same is true if I were suddenly to be determined disabled by Social Security, which means unable to be substantially gainfully employed because of injury or illness. Then the amount I would get in SSDI, Social Security Disability Insurance, would depend on how long and how much I've paid in. So a lot of times when we have a young adult, child, grandchild, or sibling, and they are applying for Social Security disability, perhaps when they're 18 or a little bit later or a little bit earlier, depending on different items, the program they're actually applying for, because they have not paid into the system, is not SSDI. It's not Social Security Disability Insurance. It's instead SSI, or what is known as supplemental security income. And this is the program under Social Security, which provides for very basic food and shelter benefits. In 2024, which it is right now, this benefit is $943 is the maximum. It is very, very sensitive. So SSI requires a recipient to have less than $2,000 in their name. There is an act currently making some movement in DC that hopefully that number will go up because that $2,000 limit's been around for way too long. But SSI is also very sensitive to any receipt of income. So even if I may not be able to be substantially gainfully employed, I might be able to work part-time. That gets offset, my earnings offset my SSI. And SSI is also impacted by the receipt of somebody else paying for food or shelter. So this is called in-kind support and maintenance. So if I'm a recipient of SSI, I'm getting $943. I'm only getting that full benefit amount so long as nobody else is paying for my food or shelter. So even if I might be the beneficiary of a special needs trust, if they start paying for my food or shelter, then their Social Security is going to reduce my SSI by 1/3. So that 1/3 in-kind support and maintenance deduction is pretty common. Sometimes when you go through the initial process, Social Security asks, does this individual pay you rent? And you say, of course they don't. They don't have any money to pay me rent. Well, if you move on and never reestablish that they are going to pay you rent, or they do start paying you rent once you've started receiving the Social Security, then you're going to get that 1/3 reduction. And so a lot of times that's one of the things that comes up. The other thing that can impact SSI for young adults is child support, because child support is technically, after the child's 18, their money, and so that would also offset SSI. So just things to know. Really important to know, though, that for an individual who has been determined disabled by Social Security before age 22, or can establish that the disability had an onset of before age 22, then later in life, once their parent either retires and takes Social Security, is they themselves eligible for SSDI, or they pass away, then the program's going to shift. It's going to shift from SSI to Disabled Adult Child Benefits, or DAC benefits. And that means that the now adult child, instead of earning the SSI, which is just based on their financial eligibility and their disabled eligibility, is going to be able to receive based on their parents' contributions. And it's a formula based on who the higher contributor was, which mom or dad. And it's going to be calculated most broadly or most commonly as 50% of that benefit amount. So while they're alive, meaning if they're getting retirement or disability, and then it goes up to 75% when that parent passes away. So for example, if I'm receiving $943 a month in SSI, but I've been receiving SSI since I was 18, my mom now retires. My mom is getting a Social Security benefit of $3,000. My Social Security is going to transition from SSI to that Disabled Adult Child Benefits. I'm going to get $1,500. And then magically, 2 years later, I'm also going to get a Medicare card in the mail. So I am also going to be eligible for Medicare well before I'm 65, because I've been receiving Disabled Adult Child Benefits for 2 years. So kind of important to understand how that all works together. In fact, I have a workshop this Friday specifically about Disabled Adult Child Benefits with another individual who that is her area of expertise. So it's something we could talk about for hours and hours, but just a highlight. And one of the things, or one of the reasons I bring this up, is because we have to know that if we have a special needs trust now, we might need to be really, really careful about the use of that distributions from that trust impacting SSI. However, if a parent has passed and we're now receiving Disabled Adult Child Benefits, the rules may be dramatically different. And so we just have to understand at the point in time that we're administering this trust or establishing the trust, what benefits are we on now, and how might that shift or move in the future. That was the quickest way I could describe Social Security benefits. So I know there's a lot left on the table, and I'm sure there may be questions about that. But moving on, in Arizona, one of our programs for those individuals who have or have been diagnosed with at least one of the following developmental disabilities during childhood is going to be a program called DDD, Division of Developmental Disabilities. The current diagnoses that meet eligibility for DDD are autism, cerebral palsy, epilepsy, cognitive or intellectual disability, Down syndrome was recently added, and it also includes those who are under the age of 6 and at risk of having a developmental disability. There's a couple new diagnoses pending. We'll hopefully get more added to the list in the coming years. DDD provides support coordination. So if you're eligible for DDD, then you're going to get a support coordinator, and that means a meeting quarterly, back to in person, with a support coordinator who's going to talk to you about establishing supports. The reality is, however, if you don't also qualify for ALTEX, Arizona Long-Term Care System benefits through Medicaid, that support coordinator is not going to have a whole lot of support to coordinate. So the funding source for most of the things that we think of as DDD are habilitation or respite care or resources. That is funded by ALTEX, Arizona Long-Term Care System benefits through Medicaid. And much like SSI, ALTEX has a lot of strict criteria to be able to be eligible. And so the common path that families find themselves is they'll get a diagnosis that met one of the criteria of DDD. They'll apply for DDD. DDD will then also start and help coordinate an ALTEX application. Sometimes the lines are a little blurry, what's DDD and what's ALTEX, but that ALTEX application will also take place. ALTEX is going to be evaluating the individual's medical eligibility, what we call a PASS, a pre-admission screening. They're going to be looking based on the age of the individual they're evaluating, ability to meet activities of daily living and care needs and behaviors and all sorts of things. They're also going to look at financial resources, and finally, they're going to look at income. And so you might imagine that these things are all changing very much during an individual's life. And so there's reevaluations based on age and need. But ALTEX, much like Social Security, is going to be really strict about how we meet this criteria. I'm going to go back a slide because I couldn't remember if I had another slide detailing these things. Generally for ALTEX, the resource criteria is that an individual, similar to SSI, must have less than $2,000 in countable resources. So when I say resources, that means at the end of the month, the carrying balance remains below $2,000. Kind of strange that it's that low, but it is still. Interestingly, the income criteria is actually going to be much closer to $2,800 a month. So an individual can actually receive a lot more income each month and still be eligible for ALTEX. But it's going to be a matter of watching both of those and making sure we're doing the right thing with the resources. Now, an individual does also legally have the ability to have a car and a home under ALTEX rules, a home with equity up to a certain amount. However, it is, as you might imagine, very difficult to maintain a home or maintain a vehicle with having less than $2,000 when the air conditioner goes out, or when you need a new roof, when you need to pay insurance and all of that. So if you're married, it's really a lot different, but I don't think that's going to be the situation we're looking in a lot of these cases. So similar to ALTEX, similar to SSI, people who are receiving ALTEX services coordinated by DDD really have to be careful with these different areas to make sure they continue to meet the financial criteria. So how are we doing? Only a half an hour in. I'm going pretty fast, but I think it's making sense. But big picture, again, we're talking about estate planning. What are the elements that kind of everybody needs to have in place? How are we going to use those tools in making sure that any beneficiary we might want to put in our estate plan who has any of these benefits, how do we protect all of that? And that is kind of the question of the hour. And again, to bring us back to a slide we've already seen, commonly we're going to use this term or this tool that is a special needs trust. So how do we provide financial support to an individual with disabilities without affecting or impacting their ability for government assistance, the programs like Medicaid that we just talked about and SSI? This type of trust allows for the management and distribution. So when we talked about trust rate, this is a very specific type of trust that's going to have very specific rules based on what type of special needs trust it is, and how do we make sure that this resource we leave behind, hoping to take care of our loved one, doesn't negatively impact all of the services we've worked so hard for or the income. And so we have to ask ourselves, what type of tool do we need? And when second slide in, had a list of all different types of special needs trusts, and we realized that there are a lot of different tools, but the big piece that we need to ask ourselves is, where is the money coming from? What are we trying to protect? And what benefits are we trying to protect? So as you can see on the diagram here, we've got a number of different boxes surrounding an individual. And so if the individual in the middle is Julie, our beneficiary, it's easier for me if I have a name. And if Julie is receiving SSI or Altex, we just learned that both of those programs are going to be very concerned that she does not have more than $2,000 on a carrying basis. Now, I put DDD on this list, but you may have noticed I didn't mention that DDD itself has criteria, but the reason I put it on there is because a lot of us in our heads put together the services DDD is coordinating with the funding source, but really it's just SSI and Altex. And to kind of compound that further, if we are the parent of Julie and we have established Julie's SSI benefits when she was 18, for example, then in fact, by the time we pass away, the only piece we're lining up there is to protect Altex. But that's just because Julie, instead of getting SSI at that point, would most likely be getting disabled adult child benefits and earning off of her deceased parent's record. So Julie can get money from a whole bunch of different scenarios. And so the question of where is the money coming from, we need to understand, did Julie win a lawsuit and is she getting a settlement? In that case, that money is Julie's. That's going to be treated differently than if Grandma and Grandpa set up a trust because they wanted to leave something for the benefit of Julie. That money is not yet Grandma and Grandpa's if they're still alive, and we have planning opportunities. Perhaps Julie is just receiving SSI and not spending it, and so her money is building up and it now exceeds more than $2,000. So we have to really understand what is the legal nature of the money that we're trying to plan for and what benefits are we trying to plan for. With that, we have a couple options. So in the scenario that I described, we want to talk about if the answer to where is the money coming from or who legally has ownership of the money, if the money is Julie's because she won the settlement, because she was an offender bender, because Grandma thought she was being generous, Grandma passed away and Julie was the beneficiary of that life insurance, that money is now Julie's. In that scenario, we have to consider different tools for protection. And so in those protection options, if we see Julie down here in the middle, we have kind of two options down here. The first being a first party self-settled special needs trust, which I'll go back to that slide. That's the big option. But realistically, we also have the ability to fund an ABLE account, which I'll talk about in a little bit. But we have to plan for this money. So I'm going to use an example, and I'm going to say that Julie's grandmother sadly passed away. Grandma didn't understand that Julie couldn't have money, and so she thought she was being very generous, and she left Julie a $50,000 life insurance policy. The first thing we need to understand is that Julie, in this case, can't have more than $2,000, otherwise she's going to lose her SSI and she's going to lose her Altex. So if we need to get her from $50,000 to less than $2,000, we have to figure out what tools are useful. First, we might be able to spend the money. We might need court permission because she might be under guardianship or conservatorship. But maybe Julie needs accommodation van and we can spend all that money in a month and it's gone. That's one option that might be available. We might also say, no, this $50,000 we need to last for Julie for the foreseeable future. We might want to put $18,000 of it into an ABLE account. That's our cap annually for an ABLE account. But we still have too much money in that case. And so in either case, when we have money that needs to be protected that we want to last, but we still want to remain eligible for SSI and Altex, we need to establish a first party special needs trust. These trusts have to be very carefully drafted, funded, disclosed, administered. These are tricky. And this is because the money already belongs to Julie. And so the government has a lot of oversight in making sure that all of these trust rules are followed. And when I say the government, I mean both SSI and Altex, Social Security and Altex. First of all, a first party special needs trust must be irrevocable, meaning we can't change it. It has to be established before age 65, so before Julie is 65. The scenario, unlikely that her grandma would die and she'd be over 65, but in a different kind of case, if they're over 65, we no longer have this as an available tool to us, so important to know. An first party special needs trust must be funded by assets belonging to the beneficiary, Julie, and the oversight of these types of trusts is going to be very strict. So for example, if Julie's on Altex, then we're going to have to get permission for all of the distributions to come out of the first party special needs trust. We're going to have anticipated disbursement worksheets, meaning a monthly budget. We're going to have one-time need for permission if it's not already on the budget. Altex will have to approve everything that comes out of the trust. Social Security has really the ability to audit every expenditure. That's because in order for a first party special needs trust to work, the trust has to say that assets at the time of termination of the trust, usually when Julie later passes away, are going to go back to the state for services. So if Julie's been receiving Altex her whole life, the state has been keeping a bill based on how much the state has funded this insurance for her, and that money is going to get paid back. And so if it's any significant period of time, for sure all $50,000 would be going back to the state, but even larger amounts, because it really does add up fast. So once the state knows they're going to get what's left over, they're going to be much more concerned about how that gets managed. You can see that in some scenarios, we're not going to have an option. We can't always prevent the need of a first party trust. In some cases, that's going to be our only option. However, when families are planning for individuals who receive benefits and have disabilities, we can prevent this. And that's going to be when we look at establishing third party trusts, when we work on putting together an estate plan to make sure that any benefit through the use of beneficiary designations, wills, trusts, however we're going to do it, we've got a couple different mechanisms as we talked about in the first part of estate planning, but making sure that anything we leave behind for Julie doesn't go to Julie individually, and instead goes directly into a third party special needs trust. And the good news about a third party special needs trust is that once they're created by a loved one on behalf of a beneficiary with special needs, and as long as it's funded with anybody else's money except for Julie's, it will not disrupt public benefits, and the trust maker can designate what to do with any funds that might remain when Julie passes. The state doesn't have a right, and therefore, at least under current law, they have much less strict oversight. So the administration of a third-party trust is going to be a lot smoother for Julie. It's going to be a lot smoother for the trustees. We get to make better use of this. In order for a third-party special needs trust to meet criteria, there's a couple of very specific rules, but broadly, it means Julie cannot be the trustee of her own trust. If she were her own trustee, it doesn't qualify as a third-party trust. Julie cannot have a right to demand any money out of the trust, and typically that results in the trust being what's called purely discretionary. It will say that the trustee has sole and absolute discretion to make distributions from this third-party trust. Of course, we're going to give you a lot of guidance about what the trustee should do and not do and how we might want it to use. But under the law, Julie can't have a right to demand or can't have any legal access directly to this money. So the good news is that these are pretty easy to establish, and they're pretty easy to administer once they're set up. The bad news is you just have to make sure that your estate plan is in place, that you've done the planning properly, including you have the right type of will, you've got the right type of trust. Your trust funding is done, meaning beneficiary designations, ownership, all of that. But these are great tools that allow us to leave that extra financial resource and to still maintain Julie's benefits. Now, I mentioned briefly ABLE accounts as kind of a third type of special needs trust or a tool that will allow us to protect some money. ABLE accounts, interestingly enough, can be funded with both first and third party resources, as well as income. So if Julie's working and she wants to save up her earnings and yet meet the $2,000 threshold, she can put her own earnings into an ABLE account. Grandma and grandpa might want to give her a $1,000 graduation gift. That can go into an ABLE account. We might have a small fender bender and Julie might get a $10,000 settlement. That can go into an ABLE account. However, annual contributions from all sources currently must or cannot exceed $18,000. That number gets adjusted for inflation, so it goes up occasionally. It's not consistently $1,000 a year, but it has been recently. So the current year is $18,000. So grandma and grandpa can't give $18,000 and Julie gives 18. It doesn't work like that. This means combined annual. So they have limited authority. Now, ABLE accounts are also permitted to be used for qualified disability expenses. So there's a lot of different good reasons to have an ABLE account for many different ways. One of the other things is it does often allow the beneficiary to have a lot more control and management of the asset, whereas with the third-party trust I mentioned, they can't have any direct control. ABLE accounts, as long as, again, they're properly funded and properly used, don't disrupt the benefits. Right now, you have to have a disability with an onset younger than 26 years. Not sure where they came up with that, but they did adjust it, but for some reason it doesn't kick in for a couple more years, but soon it will be 46. So somebody who might have an injury or a disability later in life will be able to use ABLE accounts soon. Most interestingly to know about an ABLE account, though, is that ABLE accounts in Arizona, excuse me, let me say it a different way. If the ABLE account has funds in it when Julie passes away, Arizona Medicaid agency does currently make and has the ability to make a claim against the funds remaining in there. So similar to the first party trust, the state of Arizona will make a claim for assets that remain in an ABLE account. That's changing nationally. There's a number of states Medicaid agencies who do not claim against an ABLE account, so it'll be interesting to watch. But typically for that reason, we don't want to use an ABLE account as a overall big ticket savings mechanism, right? If we want to keep money out of the state. So it's just something to be aware of. They're good tools. They have some purpose, but they're not going to be where we want to put all of our savings in, because we run the risk of the state making a claim if something should happen to the beneficiary. Okay, so common special needs trust team members, whether we're talking about first party, third party, that sort of thing, we need to think about who's going to create the trust, often called a trustor, could be a grantor or a trust maker. We're also going to need to think about who's going to manage that trust, what we'd call a trustee, who's going to have the authority to make sure investments are handled, make sure taxes are taken care of, make sure distributions are appropriate. We know that the government's going to be watching kind of no matter what type of trust we have, even if it's a third party, we still have to disclose it. They're not going to have the same level of ongoing oversight, but they do need to be disclosed. So Social Security is going to be looking at it potentially if you're getting Social Security benefits. Alltechs will be looking at it if you're getting Medicaid benefits. Financial advisors are important tools. The trustee probably wants to work with the financial advisor to make sure assets are safely and prudently invested. Beneficiaries, of course, we've got the primary beneficiary. In our example so far, that's Julie, but we also have to think about who the other qualified or remainder beneficiaries are in a third-party trust. That means maybe other family members, that might mean charities, that type of thing. They have certain rights at certain times. And of course, if it's a first-party trust, we have to understand that Alltechs or Medicaid is itself also a remainder beneficiary. We have to be mindful of that. Legal advisors, of course, I always encourage you to work with an attorney who specifically understands all these different types of acronyms and programs and benefits, make sure it's in good shape and more, because realistically, we understand that these tools are going to be very important, and they're going to be looked at sometimes by the court, sometimes in other areas. And so there's a lot of different people or team members that can be impacted by creating and having this plan in place. Quickly, I want to kind of review a couple myths just as a quiz, not a pop quiz, you don't need to answer. But the first myth is special needs trusts are only for the wealthy. I guess that could also be said for estate planning. I've said it several times, all it takes is more than $2,000 to be really disruptive to somebody's government benefits and result in a lot of legal fees or other costs to fix that. And so if you are young and you're paying for a bunch of kids and don't have a lot of savings, but your employer has a life insurance policy, or you've started an IRA or 401k, it's very easy to disrupt benefits. And so it's important to know that special needs trusts and estate plans are important for everybody in this scenario. And they're a crucial tool at different stages, and something that we want to keep an eye out. Second myth is the special needs trust will disqualify the beneficiary from receiving government benefits. You know, in the olden days, I would say it's very common to say, "Oh, I'm too scared. I'm going to disrupt Julie's benefits. I'm going to do something wrong. I don't understand special needs trust, or I've heard these things about special needs trust. So I'm just going to leave everything to the other two children, and they're going to take care of Julie." Unfortunately, life is not consistent enough to really be able to rely on that. And so we need to make sure that a special needs trust is properly set up, and so it will not disqualify the beneficiary. But the second piece to that is, just because it's properly set up and properly funded doesn't mean that a trustee who doesn't know what they're doing can't mess it up, because even distributions from the trust can disqualify them. So it is something to be really, really mindful of, and to make sure you've got a good team in place to have all that support. And then the big myth that I hear is that all special needs trusts have a Medicaid or state payback requirement. And hopefully I've made that clear. If you do your planning in advance and you are planning for assets that do not belong to the beneficiary, we can use third-party trusts which do not pay back to the state. And it's really important to make sure that those are set up, funded correctly. Occasionally, it's happened a couple of times in my career, I've had to look at a trust that somebody thought was a third-party trust, but their document preparer or their attorney didn't know what they were doing, and they were dabbling in special needs trust and probably Googled something, and they in fact put payback language into a third-party trust. Big, bad, terrible. We just want to make sure that's not in place. And so really it's empowering, I think, for individuals to know the types of documents they have in place, how they're going to work and what they're going to do, and really make sure you're armed with the information that you can review and make sure that your plan is good. If you haven't seen your attorney in a decade or so, it's probably not a bad idea to chat with somebody and just review it, make sure all the funding mechanisms are set up correctly, that the trust still complies, and that the person who initially drafted it has a good trust in place. So last, if we're reviewing this, if this is Julie, she's getting SSI in all texts, she has money herself, our options are spend it, put $18,000 up to $18,000. Oops, and I guess I used an old slide, so 17 on there still. Put up to $18,000 a year, and then the rest can go into a self-settled or first-party special needs trust. Those are going to be the ones that have payback to the state of Arizona, meaning Medicaid will make a claim when Julie is no longer using the funds in the ABLE account or the first-party trust. On the other hand, if you've done your planning and have an estate plan in place, then we're going to be able to use a third-party supplemental needs trust, special needs trust, we can call it whatever we want. That third-party trust may either be contained within your family trust or your will, or it may be standalone. It may be a trust that we've drafted and have established for Katie right now, or for Julie right now. So a lot of different ways we can do that. So big picture, hopefully that was helpful. It is 12:54. Lisa, how did I do? Did I whoops, I trying to unmute you and I actually
Yeah,
didn't mean
fabulous. You've proven to us why we hire attorneys for this.
I feel like I was talking so fast. So
It's a lot.
I said this at the start, but if you have a question and you're attending live, of course, feel free to raise your hand or put it in the question and answer. We'll keep an eye out for those. I guess, Lisa, while we're waiting to see if anybody has any questions, did you have any questions or anything you wanted me to kind of further clarify?
I do. I get a lot of, not a lot, but a substantial amount of requests from people trying to understand what they can do for their adult child with special needs, as they themselves are extremely elderly, ailing, and their child never was approved for DDD, and now they're facing these issues. So is it too late for them to kind of take care of
No,
this? No. Okay.
no, it is going to be harder. So, unfortunately, historically, there have been reasons and rules why families didn't secure benefits when they became available. Much of that may have had to do with doctors not, making diagnoses that they might make now. It might mean embarrassment of the family, so they kind of secluded a beneficiary or a loved one that, there's a lot of different reasons. And I know you can all read into those different reasons of why it didn't happen.
Right.
However, what I'll say is that DDD, for example, or Social Security, is going to want to see diagnostic paperwork, and they're going to want to see proof of onset before 22. And of course, there are a number of developmental disabilities that we know in our heads, they've always been like this, right? This is, of course, they
Right.
were, when they
Yeah.
were 6, they were like this. However, DDD and Social Security is going to want to see evidence of that. And that means they're going to want to see school records. They're going to want to see employment records. And records just weren't kept as much as they were. So sometimes that requires going back to a neurologist to do a forensic diagnosis kind of evaluation to really do the testing to say this is the diagnosis now, and based on science, this is what it would have been at these different ages. Sometimes you have to appeal decisions. Sometimes you have to push harder. All sorts of different reasons, but absolutely, it is something that should still be pursued, and is quite common that the support hasn't been in place. But if you're on the other end of that, it's my advice and my recommendation that you always try to pursue as much as you can and benefits when you can. So if you have a young adult and you're saying to yourself, well, they're making great strides in school and I really am hopeful that they're going to be able to work with the right supports, great. That's my hope too. However, when they're 18, if they're not able to at that point, we do want to establish it, because if our hopes don't pan out the way we were hoping, then we don't have the evidence. And so I'm always going to encourage pursuing those benefits. Some families say, oh, we don't need the $900 a month for the household income. That's not what it's about. We'll wait on the Social Security. And if we wait until 24 or 25, it's really, really hard to reestablish that onset before 22. And so encourage people who, great, I love it if we get to tell Social Security we no longer need you.
Right,
If we don't,
exactly.
if we get to say all text, that's enough.
Yeah,
So
later.
yeah. Yep.
There is a question in the chat.
Okay. So there's a question: what is the average cost to set up a third-party trust? So there's a number of different ways to set up a third-party trust. And the cost is hard to explain because it's different depending on who you're working with and what type of plan you need. So if it's just purely the trust, I'd say probably the average is a couple thousand. What I'll tell you though is that in my office, the way we operate is that we don't charge for consultations. So in our initial consultation about this type of topic, we do charge for some more technical types of consultations, but for an estate planning consultation, we don't charge. We look at, for your circumstances, it appropriate that you have a will that creates a trust, a family trust that creates a trust, a family trust and a standalone trust. There's a number of different options, and cost is going to depend on that. But we look at it and say what works best for you and your needs and your goals. My office does this type of planning on a flat fee, meaning you're going to know what it's going to cost. It's not X number of dollars per hour, that kind of thing. So I encourage you to meet with somebody. I'm happy to. If you want to schedule a consultation, you can do so online or give our office a call. And I know that's kind of a vague lawyer answer of it depends, but it really does based on your needs. The other thing we do to hopefully allow for families who have a lot of expense is we do payment plans up to 3 years. So that really can break down the estate planning process into digestible prices, hopefully. Who is the best to be trustee when a disabled person is the only child with no other beneficiary? So I think what I'm interpreting is that we have a situation where we have an only child, and perhaps we have maybe siblings or grandparents, but they're expected to be gone by the time the trust is being administered. Who are we going to put in as trustee? So we have this discussion as part of our consultation, and if we're moving forward with planning, it's a big part of planning, because even if you do have other kids, not always the right answer to name them as the trustee as well. So we have to look at the available options. Typically, we're looking at, yes, individuals. However, I'm always going to be hesitant to name an individual because they say they will do it. There's a lot of risk there if the money is going to be at risk for, if they make a bad decision, then that's going to be a problem. So we need to be careful naming individuals, because if something goes wrong, there's no way to get that back. We're going to look at licensed fiduciaries, so professionals who are licensed by the state of Arizona to take these types of actions. And we can also look at trust companies. We also have an opportunity to look at what's called a pooled special needs trust. So there's a lot of different options, and it's definitely going to be part of the conversation. But it's a common scenario for people who have an only child, but also for families who have other children who are too busy or not interested or not trustworthy. So we have this conversation, and frankly, in every conversation. So hopefully that helps. So I think, so what should parents do if their disabled adult child is able to obtain a low-paying job that provides for a pension? Having a job is important to that child for various reasons. The pension would not be nearly enough to cover expenses for the disabled adult child, but would cause the disqualification of certain benefits. So, and that's great to know. So when I didn't talk about this, but both Social Security and Alltex have right to work or return to work programs, meaning that if we're on SSI for a period of time, but our individual is, through school and they've done some job training and they're ready to try, Social Security is going to give us an option to start that employment process without just saying, okay, now you're cut off. Because for some individuals, we may have the skill sets to have a job, but we may have life things that make it very difficult to keep a job or to show up on time or to remain employed. And so Social Security and Alltex have programs that allow you to try to go back or return to work. And you're absolutely right, though, that employment is also very important and valuable for our self-esteem or self-worth for all of us, and something we greatly want to encourage. Typically, if the job is going to provide a pension or otherwise, if we're on Alltex, the income limit is, like I said, $2,800. But if we're over that for some reason, we're making too much money, but we still meet the other criteria, we have fixes in the Alltex, meaning we still meet medical and we still meet resources. We have what's called a Miller trust or an income-only trust. So income in and of itself, even if we're over the income limit, isn't going to make us lose Alltex. We have a solution to that. The Social Security and SSI is different, obviously, because they're looking at different criteria for disability. But yes, ultimately, whatever the specific situation is, we want to consider all of those. But again, that's not unique in the sense that we have a lot of individuals who work and receive government benefits, and we've just got to figure out what the right program is and how we kind of monitor that and are aware of that. So hopefully that helps. What other questions do we have? I just saw another one pop up. Can you have multiple types of trust at the same time? Yes. The truly wealthy have all sorts of trusts. The average family might have a couple. It's pretty common to work with my office and to set up a family trust, meaning that estate planning tool to provide for distribution of estate's assets at the time, and to have a standalone third-party trust. So you have two right there. It's potential that if Julie's parents are divorced, for example, her mom might set up a special needs trust and her dad might set up a special needs trust, and you've got more than one there. There's all sorts of reasons why there may be different types. There also may be reason to set up a first party trust and a third party trust. So yes, the answer is absolutely. You can have multiple types of trust at the same time. Hopefully that helps.
Which one would take precedence in that scenario?
Yeah, in that scenario, we're always going to want to spend the first party trust first so the state doesn't get the money back.
Got it.
Yeah, so we got to look at it. So there may be reasons that we have to tap into the third party, but yeah, typically we're going to drain or use the first party trust first if that's appropriate. Yeah. Okay. Lisa, did you have any other questions? I think I've answered everybody in the question and answer so far.
No, I don't. I think you covered all bases.
Okay. Well, I guess you don't really need to follow us, but these are my QR codes, but Lisa has her own too. And we encourage you to kind of keep up to date. And we do a lot of education events. Lisa has an awesome golf tournament in the fall, which I can't wait for. I've been taking a lot of lessons, Lisa, so I'm not going to embarrass myself this year.
We'll play together.
So let me, just go ahead and stop sharing my screen here, and we'll kind of sign off and say goodbye. Lisa, anything else you want to add?
Well, I want to say thank you for having me. If you want to stay up to date on our programs that serve young adults and our housing progress, you can again go to the website and sign up for the newsletter or the housing interest list. We already have a kind of a long list going here for the housing, but yeah, so I'm happy to help in any way I can if you need services. So thank you.
Wonderful. And I know a lot of my clients love working with you guys and find it to be a great social opportunity right now. And it looks like,
Yeah,
frankly, you guys just have a lot of fun. So I really need to
we
come
have
hang
a
out
lot
sometime.
of fun. Yes, we do.
Good. Well, thank you, Lisa. And thank you, everybody, for watching. If you have any other questions or wanted to set up a schedule appointment, please feel free to reach out to Lisa or I, and we'll kind of sign off and go from there.
Yes.
Have a great day. Thank
Thank you.
you. Bye bye.
Bye.